All right, good morning, everybody. Welcome to this online lecture. We will start in 5 minutes time. So if you still want to grab a cup of coffee, you still have 5 minutes. We start in 5 minutes time. Well, good morning, everybody, and welcome to this lecture in the course on global governance and trade policy. It's a bit, of course, an unusual lecture in the sense that we will run everything virtually. So in the next couple of weeks, we will use this software to do the lectures and organize the lectures. Let me first of all say that I really hope you're all safe and healthy, and that you can keep following the lectures as we go along in these quite unusual times. Now, before we start the lecture of today, a few words on the software we are using. So all of you have downloaded the software on your laptop or your computer or your smartphone, and you will see on your right hand side that you have a little dashboard pull out a box which we will use. And in that pull out box, there's a chat function which is on the right hand side of your screen on the bottom, and you can use the chat box if you want to ask questions or raise an issue. Just as a matter of working method is that we will not stop the lecture for each question or issue you want to raise, but we will keep track of them, and then we will come back to them at regular points through the lecture. So, but if you want, don't hesitate to use the chat box, and then just type in questions if you have them. There's also for us as organizers, we can follow all attendees who are present at the webinar, and if you really want to have a question where you want to speak out or you want to discuss something, you can flag that to me in the chat box, and then I will also activate your microphone so that you can come in and have a question. But we would prefer, if it's possible, that you would just type in the question or remark you have, and then we can come back to you on that. So don't hesitate to raise any issues, concerns, questions you have with us. We will also try to organize this as a lecture as usual as possible. That means that we will have presentations, we will have PowerPoints, you have the opportunity to ask questions through the chat box, and we will also organize a little break in between of 10 minutes. So that you can also plan that around 12, we will have a 10-minute break. So if we are all set and we see that we have now 50 people attending, we can start the lecture. So with this lecture today, we will follow up on the lecture we started off last week, where we started to map out different types of global governance instruments which directly relate to trade policy, and how global value chains work. And in the lecture last week, I introduced to you some of the major, let's say, mandatory multilateral type of agreements and initiatives which are very important in the context of trade policy. In this lecture today, and then in the next lecture, we will focus on two different sets of policies, or let's say global governance initiatives which are relevant. And today, Kari Otteburn, who is a PhD researcher at our Leuven Center for Global Governance Studies in the area of business and human rights, will give an introduction to the global governance of trade, and focusing thereby very much on voluntary governmental initiatives. So, Kari, if you're ready, the floor is yours.
Great, thank you very much, Axel. I'm excited to share with you some of these voluntary governmental rules today, because this is very much related to the research that I do on a daily basis. So let me just jump in. As we saw last week, the rapid increase in trade has had many positive effects, including economic development, innovation, alleviation of poverty, and so on. We all know the many positive effects. But as we also saw, there can be downsides as well, environmental degradation, human rights abuses, and so on. And to mitigate this and to maximize the positive effects, various actors and institutions now make up the global governance of trade. And so today we're going to be talking about the rules that are put in place by formal international organizations, similar to the ones that Axel described last week, and in some cases the same organizations that Axel described last week. But in this case, these particular rules are voluntary and they apply directly to businesses rather than to states. So just to give you a brief overview of how this course will lay out today. First, we will look at some of the limits and challenges in the regulation of transnational business. What exactly makes it so challenging to regulate business conduct, especially across borders? And then we'll go into some of the concepts that we saw in the reading for today's class, such as transnational new governance, the concept that was put forth by Abbott and Snidal in the 2009 reading. And we will also go over the governance triangle that you saw in that reading. And then we will also go into the concept of rule intermediaries, which you saw in the reading by Axel Marx and Jan Wouters. Then we will look at 3 particular voluntary governmental rules and how they're set up and organized, how they're enforced, and this kind of thing. And these are the Organization for Economic Cooperation and Development guidelines for multinational enterprises. I will call these the OECD guidelines primarily throughout this lecture because that's quite a long name. And we also have the International Labor Organization Declaration on Multinational Enterprises. Sorry, we'll call that the ILO Declaration, and the United Nations Guiding Principles on Business and Human Rights. And this is not to be confused with the Global Compact that Axel described a bit last week, which is a business-driven initiative that's voluntary. This is a different set of guiding principles. It's a different document. So we will look at that as well. So I would like to start first with a bit of a brainstorming exercise to sort of get our minds flowing with some of the hurdles in the regulation of transnational business activities. So imagine that a factory has caught fire and collapsed in Karachi, and hundreds of workers were killed and many others were injured. And a forensic analysis post-disaster showed that the factory was extremely deficient in terms of meeting basic safety standards. The factory is owned by a Karachi business owner, but nearly 100% of the factory's output is supplied to a single German clothing manufacturer, which has also provided significant investment and oversight in the factory's operations. Moreover, the factory's safety was certified by an Italian auditing firm, which was hired by the German clothing manufacturer, and which was then outsourced. That audit was outsourced to a local company. I would like you to take a couple of minutes to think about this scenario and consider if you or someone injured in this fire, or if you were a family member of someone who was killed, what hurdles do you think there might be in seeking redress? And I would like you to consider not just redress from the factory owner in Pakistan, but also consider the other companies involved, the German company and the Italian auditing firm. So while you think about this, I'll give you a minute or two to sort of ponder this, but while you're thinking, navigate to slido.com if you can open up a browser, and enter the room code trade 173. And don't worry about don't be shy. If you have an idea, please send it in. There's a great number of possible answers to this, so I'm interested to see what you might have to say. But once you're in that course, you should be able to type in an answer to the question. Now let me know if you have any difficulty in accessing that. Okay, we're getting a few responses here. I'm going to share these responses with you. Great, thank you for providing so many responses. I'll start sort of at the bottom and we'll work our way up. So we have potential for corruption in local courts, courts possibly siding with the factory owner, media attention, being fired, access to resources, no complaint mechanism, administrative hurdles, long and complicated legal procedures, the boss, difficulty in seeking reparations across national borders. These are all excellent responses. As you can see, there's a wide variety of procedural issues and also practical details. Not being able to afford legal representation has come up a few times. The fear of getting fired, complicated legal procedures and administrative hurdles. Access to remedy, cross-border issues, no access to local courts. Oh, good, and then we have establishing responsibility of company, who owns a factory, who is responsible. So you feel free to keep sending more, but I will carry on with the rest of the presentation. But thank you very much for participating in that. Those are all really great answers. So as you have all seen and described very well, there are numerous barriers to holding corporations accountable, especially when they're operating transnationally. And so this brings up the question of why is it so challenging to regulate transnational business conduct when we saw last week there are binding rules that exist at the international level. And so first of all, the rules that we saw last week that are governing trade, they apply to states and they don't apply directly to multinational enterprises. Labor standards and trade rules by the International Labor Organization, the World Trade Organization, or United Nations the rules that they impose on states must first be built into the national legal system. They have to be created as national legislation before they can apply to citizens or businesses within those states. And the rules, any standard or regulation determined by these then first have to be part of national laws. And multinational enterprises act on a global level, but laws that regulate them do not. Since the international rules must first be translated into national laws, the laws have a limited jurisdiction generally within the nation state. And yet companies act on a global level and the laws of their home state in most cases, we'll see a few examples of where this is, where there's an exception to this rule, in most cases do not apply to their activities conducted abroad. And furthermore, the right of multinational enterprises to carry out business activities across borders is legally enshrined in free trade agreements and investment agreements. And the regulation of business conduct varies considerably from state to state. The protections of human or labor rights abuses or environmental damage or problems resulting from the conduct of a multinational enterprise can be lax in some countries, can be more robust in others, but there's a discrepancy amongst countries about these types of legal rules and protections. And in some cases, there's also limited enforcement capacity of the state, especially in countries with less robust legal systems or with problems of corruption. This happens quite frequently. And there are also numerous, as many of you mentioned, in the brainstorming exercise, there are numerous practical, procedural, and legal barriers for victims in accessing legal remedy. In addition to some of the most elementary jurisdictional issues, there are numerous other barriers such as denial of justice in the country where the abuse has occurred, difficulty in securing legal representation, which many of you mentioned, the costs of bringing a claim, especially if they're going after a transnational business abroad. This can be very costly. The time, you mentioned the time it takes to access justice, inadequate options for aggregating claims and filing class action lawsuits, and also a lack of awareness about available options. In many cases, people at a local level might not be aware that they have access to remedy or that there are mechanisms in place for them to seek redress. So, and I don't know if you have seen this report yet, but there is a really interesting report that Axel and his co-authors came out with last year. And it's a mapping of cases of alleged human rights abuses in third countries by EU-based companies that were brought before courts in the European Union. And they found numerous practical, procedural, and legal barriers for victims in accessing legal remedy. And so much so that out of the 35 cases that they mapped, only 2 resulted in a favorable outcome for victims. So it begs the question of, why is this the case? And this is the subject of significant scholarly inquiry. You'll see lots of factors are involved here, and there is no single answer. But the literature has pointed to a few primary factors. First of all, that businesses are increasingly influential as political actors themselves, and with increasing power over policymaking. And as we saw in the reading for today's class by Abbott and Snidal, businesses have vigorously and successfully opposed binding regulation at both the state and multilateral levels. They resist regulation and in fact lobby for deregulation where regulation already does exist. And this is sort of aided by the economic consensus that has prevailed since the 1980s, the neoliberal economic consensus that entails deregulation and a hands-off market-based approach to business conduct, with the assumption that markets are themselves a disciplining force, and therefore firms are best left to self-regulate. This market liberalization that is pursued globally has also coincided with the rise of transnational private governance, which is called a new lex mercatoria, which is just a merchant's law. And these types of private governance have in many ways replaced or crowded out more traditional models of governance that's implemented by states. And this has occurred organically, but also, and perhaps more often, has been a deliberate strategy of businesses that seek to avoid additional regulatory oversight. And in fact, by establishing private standards and codes of conduct, businesses hope to avoid a situation that is so bad that the state really feels a need to step in with new regulation or oversight. So they try to prove that they're fully capable of regulating themselves. And not just because they're trying to avoid regulation, but also because many businesses do in fact want to contribute positively to society. So I mean, there's a variety of factors at play here. But a third major factor in why it is challenging to regulate businesses is because now so many businesses have such complicated legal structures and opaque inter-firm relationships that it is difficult to determine responsibility and even ownership. They seek to avoid legal accountability through these complicated business relationships and legal structures, and this has been referred to as the corporate veil, and this can indeed make determining liability very challenging. However, all this being said, many businesses do, of course, want to act responsibly and without harming society. And governments have also recognized that there is a need to better regulate transnational corporate conduct. And this idea that there needed to be some sort of regulation really started coming to fruition in the 1960s and early 1970s when there was a series of high-profile incidents of corporate misconduct. And so we'll get now into the trends and concepts we saw for the reading for today's lecture, which directly relates to this. So if you remember from last week's lecture, we learned that governance is increasingly conducted at a variety of levels and by actors beyond just the nation state. We also learned about formal and informal types of governance. And the reading for today by Abbott and Snidal takes this discussion a bit further by describing what they call transnational new governance. As they note in the article, there are 2 reasons for the rise of transnational new governance. The first is all of the difficulties and challenges in regulating transnational business that we were just discussing, that we just saw in the previous slides, and that you also very helpfully brainstormed in the exercise. The second is that there is often a business case for corporate responsibility. Businesses will voluntarily and proactively adopt corporate codes of conduct, or they'll make certain commitments for responsible conduct for many reasons. And these include ensuring that they have a good reputation for investors and for customers, and also to avoid the state stepping in to regulate, and of course, also for the benefits to society. So as you saw in the reading, in response to these 2 factors, there are a variety of new institutions and regulatory initiatives that Abbott and Snidal referred to as transnational new governance, and these have arisen to govern transnational business. And as Abbott and Snidal noted, these new institutions and initiatives have 2 common features. First, that private actors are central. So many of these initiatives are bottom-up initiatives, and they come driven by private firms or by NGOs or by groups of firms and NGOs, or and also the second feature is that they're voluntary in nature, which obviously means that they're non-binding on those that they're regulating. So as we saw last week, these institutions and initiatives can include private initiatives that are organized by industry groups or firms and are designed for self-regulation. They're there to regulate themselves or the rest of the industry, as well as private initiatives set up by non-governmental organizations, and they try to get buy-in from businesses and try to get businesses to adopt their codes of conduct and their governance, their regulations. And then there's also private-public initiatives, which are arrangements that are between state and private actors. So the government will actually collaborate with NGOs or with business organizations and providing sort of a state support or seal of approval on these types of initiatives. And it'll be a collaborative effort, usually without significant oversight from the state. It's usually driven by the private actor, but sort of approved by the state. And third, there are traditional governance institutions, such as the state and international organizations, that set up new initiatives that are meant to directly target firms rather than governments. And that's the category that we're going to be discussing during today's class, the types of governance that come from traditional actors, like international organizations, but are targeting firms. And these are voluntary in nature. And then next week, you'll hear from my colleague, Charlene DePorter. She'll be discussing the private-led initiatives that we were just discussing. So next, we'll look at the governance triangle that you saw in the reading for today. The governance triangle sort of lays out the fact that there are three primary groups of actors involved in regulating transnational business activities in transnational new governance, and that's states, firms, and NGOs. In the first zone, we have the most traditional group of actors. I don't know if you can see my cursor, but the first zone is the one at the top, and that is the type of governance that is conducted by states and intergovernmental organizations formed by states through treaties and international agreements. And here we would place all of the regular national legislation that governs business conduct, labor laws, etc. But we can also place initiatives by intergovernmental organizations, so long as they apply directly to businesses and do not first need to be implemented by states. And so you see here we have the OECD that we'll be talking about today, right there. And then in zone 2, we have, that's on the bottom right, we have the private initiatives set up by firms that we mentioned previously and that you will learn about next week with Charlene. And these include company or industry codes of conduct. And then in zone 3, we have the private initiatives that are set up by non-governmental organizations, such as labor unions, consumer organizations, research institutes, solidarity groups, human rights groups, watchdog groups, you name it. And they frequently will set codes of conduct, which they then try to get firms to adopt through a variety of strategies, including lobbying or creating public awareness about certain issues, naming and shaming, getting the media involved, and putting pressure on specific companies. I'm sure you're familiar with some of these initiatives, but you'll see more of those next week. And then in zones 4, 5, and 6, we have sort of these hybrid types of governance that combine two of the actors. And in zone 7, we have all three combined. So in zones, we have the zones of government and firm collaboration in zone 4, and joint initiatives between firms and NGOs, such as voluntary sustainability standards in zone 6. And then we have partnerships between governments and NGOs in zone 5. And then all three are in zone 7, and we'll actually be talking about one of those today, which is the International Labor Organization Declaration for Multinational Enterprises. And this one is in this section because even though it's led by the ILO, which would be an international organization, it's a tripartite declaration that brought in trade unions and business representatives and governments to create this declaration. So it's got all three actors involved, so it fits into zone 7. And then the others that we will discuss today will primarily be from zone 1. And so next we'll go into the concept of rule intermediaries and the RIT framework that you saw in the reading for today by Axel Marks and Jan Wouters. And last week, Axel introduced the idea of rule makers and rule takers in global governance. And building on this, the RIT model, which is the regulator, intermediary, and target model, which was introduced by Abbott, Snidal, and Levifauer in 2015. It recognizes that many regulatory processes in global governance do not work on the basis of formal delegation, as in a principal agent type model, or the rule maker, rule taker model, but they rather work through other regulatory mechanisms and regulatory chains that involve different intermediaries. And in some cases, these are secondary regulators. And so as you saw in the reading for today, Axel Marx and Jan Wouters apply this framework to the global regulation of labor standards. And in this case, the rule maker or the regulator is the ILO, and the rule taker would be the employers. But between these two groups, between the international organization, the ILO, and the rule taker, employers, there are a variety of intermediaries along the way that gets the ultimate principles from the original ILO declaration and the conventions to be implemented by employers. And so these can be delegated intermediaries or non-delegated intermediaries. And not to oversimplify things too much, but we saw in the reading that some of the delegated intermediary is the committee of experts on the application of conventions and recommendations. And this group is responsible for ensuring member states' compliance. And then we also have undelegated intermediaries. And in the reading, we saw that two of these were the OECD guidelines for multinational enterprises and also the Fair Wear Foundation. And so the OECD guidelines is an international organization-led voluntary governmental effort that we'll be discussing, and the Fair Wear Foundation is a private-led initiative. And so but there's other non-delegated intermediaries involved in this chain, as we will see, and two of them that we'll actually look at today will be the ILO's own voluntary instrument, and then also the UN guiding principles. Both of these incorporate labor standards from the original ILO declaration, so they can also be considered non-delegated rule intermediaries. So as promised, we will now turn to the voluntary rules set up by these more traditional governance actors, such as states and formal international organizations. These guidelines are meant to fill the gap in regulation of transnational business activities by directly targeting businesses of adhering states. They are unique governance initiatives in that they are agreed to by states, and states generally have legal obligations towards implementing them, but they're technically voluntary for businesses. And today, as I mentioned, we'll be looking at the three most important for the governance of transnational business activities, which are the OECD guidelines for multinational enterprises, the ILO's declaration, tripartite declaration on multinational enterprises, and the UN's guiding principles on business and human rights. The first two, the ILO and the OECD guidelines and declaration, came about in the 1970s. When the regulation of transnational corporations became a bit of a hot topic, as I mentioned, there were some high-profile scandals. At this time, the United Nations set up the Commission on Transnational Corporations with the intention that it would create a set of binding rules for transnational business activities. However, after years of negotiation, no agreement was ever reached, and the effort was eventually abandoned. In the meantime, however, the OECD and the ILO set up their own non-binding instruments in the 1970s. And then several years later, as we will see, the UN Human Rights Council endorsed the guiding principles on business and human rights, but this instrument is also non-binding. So the effort to establish a binding agreement was abandoned, at least for now, and we have the rise of these three non-binding instruments coming in to fill this gap. So today, this situation remains the same. There are still no binding international rules that apply directly to multinational enterprises, and these non-binding rules are at the moment sort of the best we've got, but at the end, we'll discuss a few, we'll look ahead to the future and see what might be next in this regard. So first, we'll go into the OECD guidelines on multinational enterprises. And since not everyone might not be completely familiar with the OECD, I'll briefly go over the organization itself. The Organization for Economic Cooperation and Development was established as a successor to the Organization for European Economic Cooperation. So you European studies majors might be familiar with this. This organization was established in 1948 to organize and run the US financed Marshall Plan for Reconstruction after World War II. And Canada and the US joined the original members of the OEEC to form the OECD in 1961, with the goal of cooperating to further economic development. And at the time, the countries that were involved were mostly like-minded countries, democratic countries, market economies, and committed to market liberalization. This is still more or less the case. The OECD now has 36 members, and as you can see from this map, if you can you can see the blue countries throughout the map. These are generally higher income countries with market economies and democratic governments. So the organization is promoting a free market and is interested in shaping policy to facilitate economic development through free trade and investment. And you may also know it from the many statistics that it publishes. It produces a variety of statistics on a range of indicators for different countries' development. And you may know it through that. So in the mid-1970s, at the time 24 OECD member governments came together to agree to a set of guidelines for multinational enterprises. The UN was also attempting to create regulation, like as I mentioned at this time, but as I said, this was abandoned. And so the OECD member states adopted the guidelines for multinational enterprises in 1976. And these guidelines have since gone through 5 revisions. And the most recent revision was in 2011. And at this time, the guidelines went through a major update that included the addition of a human rights chapter for the first time, and which was based on the United Nations Guiding Principles on Business and Human Rights, which we will be talking about in a little while. This update also added a new and comprehensive approach to due diligence, also inspired by the United Nations Guiding Principles on Business and Human Rights. And it also strengthened some of the other chapters. It also added procedural guidance, which is a set of, it was basically just a set of guidelines to strengthen the role of the guidelines grievance or dispute resolution mechanism, which we'll get to in a little bit. They're called national contact points. So it was a major update, but today, partially because of this update, but also in general, the guidelines cover a very wide range of issues. They have a very broad scope. They include human rights and labor rights, information disclosure, environment, bribery, consumer interests, science and technology, competition, taxation. It's very broad, covers generally all activities related to business. And today, 36 OECD members plus 12 other countries have ratified these guidelines. And I'll refer to those as adhering states throughout the rest of this lecture. When this was set up, they were developed in consultation with business associations and trade unions, and the voluntary and flexible nature of the guidelines was really highlighted and pushed in order to gain the support of multinational enterprises and business associations. And in fact, businesses did respond positively, and they saw their support for the guidelines as a way to sort of preempt more binding international regulations. As I mentioned, the UN was trying to adopt a more binding set of regulations at this time. And this quote from the Confederation of British Industries newsletter to their members on interested in issues affecting international investment in multinational enterprises, that's the name of the newsletter, in October 1979 demonstrates this perspective. I'm just going to read it out because I think it's a very interesting quote. The voluntary and flexible nature of the guidelines means that they are far preferable to the alternatives being discussed in other international fora, such as the UN, where many of the proposals put forward would have serious implications for the operation of multinational enterprises. Widespread support for the guidelines will serve as a potential moderating force on the deliberations of these other fora by showing the practical value of a reasonable voluntary code operated with the active support of governments, employers, and workers. So as you can see, they weren't there. The idea of preempting a more binding regulation is not a hidden message here. It's very clear that this taking on this voluntary code, or this voluntary guidelines enthusiastically would be a good way to preempt other types of more binding regulations and to show that they didn't really need to be bound by anything mandatory. And so for a long time, the OECD guidelines remained well within the territory of being wholly non-binding, voluntary recommendations. And this was more or less the case until 1984, when they established national bodies to operationalize the guidelines through promotion of the guidelines and the provision of a non-judicial mechanism for addressing complaints. And this was called the National Contact Points. However, even this setup of the mechanism remained dormant until 2000. And so for a long time, there was really no way to operationalize the guidelines or to enforce them. Even though there was technically a non-judicial mechanism in place, it was in complete disuse for many years. However, in 2000, this changed with the revision of the guidelines that, among other things, gave NGOs, individuals, and civil society the right to submit complaints to these national bodies, and also expanded the scope of activities covered by the guidelines to include activities in non-OECD member states committed by companies from OECD member states. Previously, this was a source of contention, and in 2000, for the first time, it was very explicit that activities that occurred abroad in third countries, in supplier countries, by companies from the OECD member states qualified, they could be brought to these national bodies as complaints. So today, the national contact points are the primary non-judicial mechanism that helps enforce the guidelines, and they're a really unique non-judicial mechanism in all of these things because they actually do have a bit of a hard edge. They sort of sometimes, some scholars say that they cross the line into a harder type of law, even though they're technically a soft law instrument. So each state adhering to the guidelines is required to set up a national contact point. Because the guidelines are technically soft law and therefore non-binding, the national contact points are meant to operate as a mediation platform where relevant parties come together to work constructively towards a future-oriented solution that is in the interest of all parties. And that is obviously a quote from the guidelines. And they have a two-part mandate. They are meant to promote the guidelines in the countries where they operate, but also to handle disputes. And the second part is the part that we're mostly interested in today, so that is what I'll go into. The dispute settlement mechanism is called the specific instances procedure. So national contact points handle specific instances, which are the cases that are brought forth by a complainant, which, as I mentioned, could be an NGO, could be individuals that are victims of a corporate human rights abuse or an environmental degradation caused by a corporation. The NCPs differ somewhat in who is allowed to bring a complaint against whom, with some requiring the complainant to have a close interest in the case, but others actually admit cases from third parties, such as NGOs. The NCP guidelines are a bit broad on this point. The complaint should generally be brought to the national contact point in the country where the alleged breach of the guidelines occurred, which is the host country. But if there is no NCP in that country, for instance, if the breach occurred in a country that's not an adherent to the guidelines, then the complaint may be made at the NCP in the country where the multinational enterprise is headquartered, which is the home NCP. Sometimes you have a situation where multiple NCPs are involved, and there's a variety of procedures in place to determine which NCP should ultimately take that case. But this non-judicial mechanism allows stakeholders to make a complaint against a multinational enterprise from any adhering country, even if their own country is not an adherent to the guidelines. And this is really important because, as you see with supply chains, as we talked about last week, you have companies that get supplies from and operate in many countries that are developing countries that might have less robust legal systems in place or less robust human rights frameworks. So it's really important that a victim in a third country that is not an adherent to the guidelines and is not part of the OECD is still able to bring a complaint against a multinational enterprise that's operating within their country across borders. So this is a really unique part of the NCP process, and it's different. This is where it really stands out from international courts, or from national courts, which generally their jurisdiction only applies to the edge of their borders. So this makes it a fairly unique feature and a unique non-judicial mechanism. And also because the guidelines contain prescriptions for multinational enterprises to exercise due diligence in ensuring the conduct of their suppliers and business partners also meet the guidelines, complaints can also technically be made against a multinational enterprise if one of their suppliers, and not the company themselves, breaches the guidelines. So the way it works is that the NCP first determines admissibility, including assessing whether it is the correct NCP to handle the specific instance and whether the alleged breach is indeed a breach of the guidelines, if it is material and substantiated, and so on. And if it is not accepted, then a statement indicating why it's not accepted is published, and these are public documents. And in general, they're supposed to include the names of the company and the complainant, and the reason why it's not published or reason why it's not accepted is also supposed to be included in these statements. And so these statements have a public character, which is also a very interesting feature of this mechanism. But if it is accepted, then the case goes on to the next stage. And here the NCPs differ somewhat in how they handle specific instances, but they're all supposed to offer their good offices, which entails dialogue, mediation, and conciliation services to both parties. So they're supposed to try to get the parties to reach an agreement through mediation first. But in cases where mediation fails, some NCPs also evaluate the facts of the case to make a judgment as to whether or not there has indeed been a breach of the guidelines. Some NCPs in this examination process even conduct their own fact-finding and might consult with other NCPs, officials. They might even do a country visit. The NCPs vary quite considerably on this point, but the point is that they have the mandate to do so if they so choose. At least some NCPs view it this way. Then the process is concluded when the NCP publishes a final statement, and the NCPs also vary by what is included in this statement. Some NCPs state the bare minimum, for instance, that the mediation took place, that agreement was or was not reached between the parties, but others, especially those that hold the view that they should conduct an examination and actually make a judgment as to whether the guidelines have been breached, they also include in the statement a judgment as to whether there was a breach, and also sometimes they include recommendations as to how the company in question can better implement the guidelines for which it was deemed to be in breach. The whole process is meant to take less than a year, and decisions made by the national contact point are not legally enforceable, and a multinational enterprise is not obligated to participate in the mediation procedure. As we've mentioned, this is voluntary and it's non-binding. So if a complaint is brought against a company, the company is notified, but the company can then decide whether or not to participate. It doesn't have to provide information or implement the recommendations. It's completely non-binding technically. However, because the statements are published publicly and the examination procedure can go on with or without the participation of the company, some scholars see this instrument as sort of crossing the line into hard law, because in the end, the multinational enterprise cannot really opt out without consequences. Because if a statement is publicly published with their name and it says that they refuse to participate in the proceedings and this is how the proceedings went, then technically there is still this naming and shaming mechanism that that has consequences for the business. It could have consequences for investor relations, customer satisfaction, etc. So some see this instrument as sort of in the gray area between soft and hard law, because while technically non-binding, there are real effects. However, there's no real way to follow up on the recommendations. The NCPs don't then a year later check with the multinational enterprise to see if their recommendations have been implemented. So, you know, it's still very much in a gray zone, and it's a soft law instrument by and large. But as I've already alluded to, the NCPs vary quite considerably in how they're structured, also how they perceive their role, how they handle specific instances. And this is in large part due to the extremely flexible, some might say vague or imprecise language in the guidelines and in the accompanying procedural guidelines for the national contact points. The guidelines are really not explicit as to how the national contact points should be set up or how their activities should be conducted. And so as a result, there is considerable diversity in how the national contact points are actually organized. Some are housed within government ministries and others operate more independently. They're staffed differently, they have different budgets, the guidelines really just state that the adhering state needs to set up an NCP, fund it, and staff it. But they also identify several possible structures for how this can take place. It could be monopartite, which is located in a single governmental department. It could be interagency, which would be set up with representatives from several different departments that would sort of broadly comprise the national contact point. It could be pluripartite, which includes representatives from government and from business and civil society, or it could be an independent expert body consisting of independent experts. So as you can see, this is quite different, with some NCPs operating very much like a government ministry and therefore appearing to have all of the trappings of government authority. And then others are sort of more an independent body on best conduct, and they might have a slightly different approach. They also differ in how they handle complaints. For instance, a complaint must be brought within to the Danish NCP within 5 years of an alleged breach of the guidelines, whereas there's no time limit at the UK and the Norwegian NCPs. And 5 years might seem like a long time, but actually this can be a problem for breaches with effects that take longer to show up. As Olsen and Sorensen point out in a piece that looked at several different NCPs and the different ways in which they're structured, environmental harm caused by certain business activities may only become apparent after many years. If there's chemical spills that show up later in types of cancer rates in a certain area, for instance, this may take years to actually show up, and the 5-year limitation with the Danish NCP would therefore be a problem for those victims in accessing remedy with the Danish NCP. Furthermore, the national contact points vary in terms of how they determine jurisdiction, who is eligible to bring the complaint, whether NCPs can initiate cases of its own motion, some do, and seek out its own information on a case rather than relying on the information provided by the complainant. And also, NCPs have very different viewpoints about their own role. The guidelines are very clear on 2 points: that the NCP must publish a final statement, no matter at which stage the specific instance procedure is closed, and also that the national contact point may provide recommendations to the firm allegedly in breach of the guidelines. So some NCPs, such as the UK and the Norwegian NCPs, take the viewpoint that in order to provide recommendations, it's necessary to first determine whether or not there has been a breach. Thus, if the company in question refuses to participate in the mediation procedure, or if no agreement is made through the mediation procedure, the UK and the Norwegian NCPs will nevertheless conduct an examination of the facts to determine whether there has indeed been a breach. In this case, they make a judgment and they include the judgment in the final statement along with recommendations. However, other NCPs point to the voluntary nature of the guidelines to argue that they should not go beyond providing anything more than a mediation platform. They say anything beyond that is counter to the voluntary nature of the guidelines. So the Canadian, US, and Mexican NCPs, for example, all the North American NCPs, take the position that if the company that is allegedly in breach refuses to participate in the mediation procedure, then the specific instance should be immediately brought to a close and should not go forward at all. And they, in their statements, they just published the bare minimum saying that the mediation could not proceed. They do not view it as within their mandate to conduct an examination of the facts or to make a decision as to whether or not the guidelines have been breached. So you can see already that there's a huge difference between the UK NCP, the Norwegian NCP on the one hand, that view their role as a more judicial mechanism versus the strictly mediation platforms of the American NCPs. And as I mentioned, there are a total of 48 NCPs, and they all fall within one of these categories or somewhere in between. And so there's quite a bit of variation among the NCPs. But next, I'm going to go into some of the numbers to help illustrate the usage of this dispute settlement mechanism, because as I mentioned, it was completely dormant from 1984 to 2000. It started picking up after 2000, but most recently, after the 2011 update, it really started to gain some traction. So far, more than 450 specific instances have been filed at national contact points. And this number has been steadily increasing year over year, with a record high in 2018 of 52 in a single year. So as you can see, this is not used as much as some of the other international courts or other types of and certainly not as much as national courts, but it is increasing steadily, even though it's still relatively, the use is relatively limited. Also, this increase appears to be largely driven by NGOs, who have accounted for approximately 50% of the specific instances submitted in recent years. And next, we'll look at which NCPs are the most active, because as I mentioned, they vary in terms of their structure, but also this has ramifications for how active these NCPs are. As you can see, the cases are not equally distributed. The UK national contact point has more than twice as many as its nearest competitor, which is the US. And you can see at the bottom, some countries are barely active at all and have just processed one specific instance each. Partly this has to do with when they became an adherent to the guidelines, when they were adopted, but also it has to do with how many multinational enterprises are working out of that country or are home based in that country. Obviously, the US and the UK have a lot, so it sort of makes sense that they're more active than some others, but this doesn't account for all of the differences. We can't explain, for instance, the difference between the US and the UK using number of multinational enterprises, because the United States has more multinational enterprises than the UK. So obviously this can't completely explain everything. The variations can also be a consequence of differences in how active the NCP is actually in promoting itself and raising awareness about the guidelines and the dispute settlement mechanism. Many people may have never heard of the national contact points, and I imagine that many of you have never heard of the national contact points. So as you can imagine, promotion has quite a bit to do with it as well. It can also reflect the confidence of civil society and NGOs in their home NCP, whether they believe it's actually an effective mechanism and whether they believe it can make a difference. They won't bother pursuing a specific instance if they find that their requests are repeatedly denied, or they stop before they even get to the mediation stage. So you can see that it has a bit to do with their perception of how effective these mechanisms are and if they actually are a worthwhile tool in seeking access to remedy. Next, we'll look at some of the issues that are covered by these NCPs. As you can see, the 2011 update had a major impact on the issues being brought before the NCPs. The inclusion of a human rights chapter resulted in an explosion in the number of human rights cases brought before the NCPs. In 2018, the most frequently referenced chapter was the General Policies chapter. In the past few years, the three most common complaints brought to NCPs reference the chapters on general policies, employment and industrial relations, which are the labor rights issues, and human rights. And the OECD explains that the frequent citation of the general policies chapter is mostly attributed to the fact that the due diligence expectation on companies is included in that chapter. So if somebody is going after a multinational enterprise due to something with their supplier or something in their supply chain, they would have to use the general policies chapter. So those are the three most commonly referenced chapters when making complaints. And the due diligence processes, they often underpin adverse environmental and social impacts. So they also might be considered environmental or human rights issues in the end, but in the end, it's the general policies chapter. So you've already probably gotten an idea of some of the potential problems faced by these national contact points. But as you can see, there is a lot of incoherence and variation among NCPs, and many scholars and commentators and rights activists point out that this negatively impacts how the mechanism is perceived as a whole. Additionally, there is a lack of enforcement capacity. Beyond the naming and shaming, which we discussed, the NCPs do not have much more enforcement capacity because the guidelines do remain voluntary. And so, like I mentioned, they don't follow up with companies to determine whether they have implemented the recommendations. And they can't sanction a company, they can't give a fine to a company, and there's no remedy for victims in these scenarios. So there's a bit of a lack of enforcement capacity. Some scholars and commentators find that they're intransparent and illegitimate. It depends on obviously the NCP. Some have doubts as to their underlying motivations. Were they set up to preempt mandatory legislation? This goes back to the original set of guidelines and the original purpose for creating the guidelines. Some doubt whether it is legitimate that firms cannot opt out of the NCP mechanism without consequences. Since it is a voluntary mechanism, Is it legitimate that they will still have negative consequences even if they choose not to participate? And then some NCPs are accused of being non-transparent by not publishing the full details of a case or providing vague or generic reasons for not accepting a case. And as you can imagine, this is more the case for the American NCPs that take it in the viewpoint that they shouldn't be making judgments or really publishing whether or not they believe there to be a breach of the guidelines. Limited awareness is also another major problem. They're relatively unknown, which means that civil society, NGOs, and individuals, especially in non-OECD member countries where many of the multinational enterprises suppliers are located, may not be aware of the instrument at all and therefore cannot use it. And also there's limited access to remedy. As the OECD Watch, which is an NGO that follows up on these cases and keeps a big database of the national contact points. So if you're really interested in this, I encourage you to check out the OECD Watch website because you can get lots of information on all the available cases and the decisions, and you can see all of the public documents. The year 2008, I'm just quoting here, the year 2018 was not a good one for remedy under the OECD guidelines for multinational enterprises. Just 9% of cases filed actually reached agreement. 9% is slim odds to justify the extensive time and energy required to file a complaint. So despite the fact that this can be used by great many people, in the end, last year, just 9%, or in 2018, just 9% of the cases filed actually reached an agreement. So some point to the fact that this still remains a limited tool. And actually more than 52% of specific instances filed are rejected in the initial stage. So there are many limitations to this tool that remain. However, as I mentioned, it is one of the most unique mechanisms in global governance of transnational business activities. So it remains to be seen exactly where this will go in the future. But I think it's time for a break. Is that right, Axel?
Yes, that's fine. But maybe before we go into the break, there was one question related to the NCP. So maybe you can answer that now. The
Absolutely.
question from a student who says that if the NCPs do not have any jurisdiction power nor give advisory opinion, then what's really the matter to have the right to examine facts and make final judgments? So what's the whole point of having these NCPs?
So they're primarily a naming and shaming mechanism. So if they actually are able to hold the examination, as some NCPs view it within their mandate, then they can determine whether a company has been in breach of the guidelines, and they publish that publicly. So then investors can see that, as well as media and human rights watchdogs, and it could become a problem for the corporation's reputation, and so therefore it has a bit of teeth. And that is that the fact that the NCPs can look at companies' due diligence processes and their relationships with suppliers and comment on that, as well as the company's own activities, makes it an interesting tool. And I think that's what you were asking, but if I didn't fully answer that question.
Yes, I think that's right. I also just want to add that it's important to note, and it was also in your slides, that there's actually quite a lot of variation between how the NCPs function across countries.
Yeah.
And some NCPs do not really see themselves as having a real primary objective of chasing companies and holding them to account. And in those cases, there's not really much of, let's say, activity on their side to check facts, to name and shame, and to bring it out. Some other NCPs, which Kari showed, are far more effective in that way. And in that sense, in those contexts of those NCPs, it's very important that they can examine facts, that they can make a final judgment, because as you rightly said, that can be picked up by NGOs, that can be picked up by investors, that can have an effect. So I would propose we now have a 10-minute break and we reconvene at 12:16.
Sounds great.
Okay, see you in a bit.
Okay, we'll get started in just 2 minutes.
Okay, we will get started soon again. Maybe just one small point of attention. I see that quite a few students are also watching other screens. So please stay tuned to the lecture and to the webinar so that you can follow the slides carefully at the lecture. Thank you. Kari, are you ready?
Yes, I am. Yes, let me just pull my video back up. Okay. Okay, now we will turn to the International Labor Organization and their Declaration of Principles Concerning Multinational Enterprises. Last week, Axel introduced the ILO and its Declaration on Fundamental Principles and Rights at Work, which, as you saw, is binding on states. Around the same time that the OECD members were drafting the guidelines for multinational enterprises, the ILO also recognized the need to provide explicit and specific recommendations to multinational enterprises with regard to labor-related issues. Thus, in 1977, the Tripartite Declaration of Principles Concerning Multinational Enterprises and Social Policy was adopted. Unlike the Declaration on Fundamental Principles and Rights at Work that you discussed last week, which is binding for states, this declaration for multinational enterprises is meant to serve as a voluntary set of guidelines for businesses, much like the OECD guidelines that we just discussed. Like the Declaration on Fundamental Principles and Rights at Work, however, it does draw legitimacy from the fact that it was negotiated and drafted by a tripartite committee consisting of employers, government representatives, and trade union representatives. It has been amended 3 times, and the most recent version was adopted in 2017. According to the declaration, its primary aim is to encourage the positive contribution which multinational enterprises can make to economic and social progress and the realization of decent work for all. Though it's non-binding, it has moral and normative value, and the ILO stresses that it can be used as a framework for trade unions when negotiating with their governments for stronger legislation or with employers. A trade union can point to a chapter in the declaration and say, for instance, this is an internationally recognized labor standard. It's in this declaration. We should ensure our legislation meets these standards. So that's where it has a bit of normative value. Also, it applies to all businesses, governments, and trade unions of all ILO member states, which at the moment is 187 states. As you can see, it therefore applies to many more states than the OECD guidelines, which only applies to 48 states. However, its scope is much more narrow than the OECD guidelines, as it only covers labor and employment related issues, whereas we saw that the OECD guidelines covers many other issues from environmental degradation to bribery and corruption. So you can see a little bit some of the differences between these two instruments already. I also would like to share this quote from the introductory text of the most recent version of the guidelines to demonstrate the strong emphasis on the voluntary nature of the guidelines. The parties concerned have the opportunity to use the principles of the Multinational Enterprise Declaration as guidelines for enhancing the positive social and labor effects of the operations and governance of multinational enterprises to achieve decent work for all. Given this emphasis on the voluntary nature, it may not be surprising that there is no real enforcement mechanism or mechanism through which a potential victim of the breach of this declaration could seek remedy. However, this doesn't mean that they're without value. Because the ILO has normative authority, the principles have been included in other types of agreements, such as trade agreements and international treaties, and even in national legislation, which can mean that the declaration has, by extension, some binding effects. Aside from this, the ILO Multinational Enterprise Declaration does include some of its own implementation mechanisms that have been put in place more recently to attempt to improve the effectiveness of the declaration, which had been a source of criticism earlier on. So now we'll turn to how it looks in practice. The promotion is to take place promotion is to take place at regional, national, and international levels. At the regional level, a regional report on implementation of the declaration is supposed to be prepared every 4 years before the ILO regional meetings. The report is based on inputs received to the questionnaires sent to governments, employers, and worker organizations of the ILO member states of the specific region covered. The reports are submitted to the ILO governing body, and this mechanism has been in place since 2014. So at the moment, it remains to be seen how effective it is because of the 4-year cycle. There haven't been very many of these done so far, but it is interesting that there are questionnaires sent out to governments, employers, and worker organizations to get a broader base of information to see how these declarations are being implemented. At the national level, states are now encouraged to set up what are called national focal points, and this has been in place since 2017. So again, it's a new mechanism for implementation. The national focal points are meant to promote the guidelines and the declaration and to raise awareness nationally about them. And it's entirely voluntary, of course. So far, 5 countries have set up a national focal point, and that's the Ivory Coast, Jamaica, Norway, Portugal, Senegal, and Sierra Leone. Scholars have been somewhat cautiously optimistic that this could be a useful tool for promoting the declaration, but it's not quite clear how far these will go. And since it's been adopted only by 5 countries so far, there's not a lot of information out there on its effectiveness. Third, at the international level, there is the ILO Help Desk for Business on International Labor Standards. This office is tasked with providing technical assistance about the declaration and also confidential information services for governments and businesses. So if they have a query on how to interpret one of the principles in the declaration, they can reach out to the help desk for clarification. And the confidentiality of this service is stressed very strongly in the guidelines. The second implementation tool that we're going to discuss is that is available for this declaration is the company union dialogue. And basically this tool is meant to serve as a neutral platform to discuss the application of the Multinational Enterprise Declaration. The trade union association can contact the ILO office to request this, and the ILO will reach out to the relevant firm or firms who can agree to participate or they can decline, much like the national contact point process. However, if they decline, the tool stops there. If they agree, then the mediation process takes place as long as both parties remain willing. It is not meant to reach a judgment on any violations, but rather to discuss application of the principles. So in this sense, the tool is a bit more clearly defined than the national contact points of the OECD. In this case, it is very clear that it's just supposed to be for mediation and not to make a judgment. The ILO explicitly takes the stance that it can neither sanction nor even shame a party that's part of these proceedings. It is strictly for mediation. Moreover, the procedure puts a major emphasis on ensuring complete confidentiality throughout the whole process. Firms are not even named. So we actually don't know very much about this tool because it's so confidential that we don't know how often it is used, by whom it is being used, if it's being used at all, because it's all very confidential. And then finally, there is a procedure for examination of disputes. And this is intended to interpret the principles of the Multinational Enterprise Declaration if there is a disagreement as to their meaning that has arisen from an actual situation between the parties to which the declaration applies. So for instance, a trade union and a business. The request of interpretation may be made by just a small subset of these people or these groups to whom it applies. So it can be made by the government of a member state acting either on its own initiative or at the request of a national organization of employers or workers. So by the governments, by itself or on behalf of someone else, or by a national organization of employers or workers, which is representative at the national and sectoral level, or by an international organization of employers or workers on behalf of a representative national affiliate. So as you can see, these are all very high level. They have to be very internationally represented in order to make a request at this, for a procedure, for an examination of a dispute. Individual victims or groups of individuals cannot request interpretation. An individual trade union could not request an interpretation, for instance. Once a request is received, the Office of the ILO may consult the governing body of the ILO and any relevant facts of the case in order to provide a reply, which is then approved by the governing body and sent back to the person or to the group that has requested it, whether it's a government or an international organization. However, because this is also a confidential process, it is not clear exactly what the reply consists of beyond a clarification of a principle with respect to a particular situation. So again, this is all quite unclear, but they are meant to at least clarify the principles with respect to a situation should it arise. Obviously, you can already probably guess some of the challenges and criticisms that scholars and commentators point out, but some legal scholars have pointed out that it's entirely unnecessary that the ILO Declaration for Multinationals use such vague and conditional language. They use the word should a lot and may and these types of things that are very voluntary in nature. But they point out that this is rather unnecessary because many of the principles that are in this declaration already exist as binding standards of protections in other international agreements, even the ILO declaration, the original one. For instance, the abolition of discrimination at work and the use of forced labor are already well enshrined in national legislation and in binding international treaties. So the use of conditional language on this principle, which it is conditional in this declaration, is seen as unnecessary by some scholars. Also, the quote I shared earlier demonstrates the emphasis on the voluntary nature of the declaration. Further, as we have seen, implementation tools are underutilized and appear to have limited impact so far. Again, some of them are rather new, so it remains to be seen how they will work out in the end. But the continued emphasis on confidentiality and the lack of transparency can also undermine the perceived utility of these tools by victims of breaches of the declaration. And so far, only 5 countries have established the national focal points. So this tool also remains limited, though it may become more relevant in the future. But perhaps most problematically, the implementation tools do not really constitute a genuine enforcement mechanism, and there is no opportunity for redress for victims of potential breaches. Victims themselves are unable to make use of the implementation tools that are in place, as we just saw. And the tools are designed to provide confidential advice and mediation and not really make a judgment or to provide remedy. So these are some of the limitations of the ILO declaration, though it does have normative value, as we discussed. And next, we're going to be going into the UN Guiding Principles on Business and Human Rights, which is the third voluntary governmental instrument that we're going to be looking at today. This instrument is the newest of the 3, and it came into existence in 2011. However, despite its recent advent, it has already had significant normative impact and generated a lot of international attention. So it's already become part of international dialogue about human rights. For much of its history, the regulation of transnational business has generally left out business's impact on human rights and the role of business in preventing human rights violation. It has focused instead on other issues like bribery, corruption, taxation, and unfair competition. In fact, the OECD guidelines that we discussed first did not even have a human rights chapter, aside from 2 labor standards, which can be considered human rights, in my opinion. Did not include any other human rights standards in its original version. and really only included human rights after the guiding principles were adopted in 2011. But the conversation about human rights in businesses started to really take off in the 1990s. If you are familiar with the UN Secretary General Kofi Annan, he is credited for bringing this discussion of business impacts on human rights to an international level. And in 2005, he appointed John Ruggie as Special Representative of the UN Secretary General on Human Rights and Transnational Corporations and Other Business Enterprises. Can you imagine that on a business card? So John Ruggie's task was first to identify and clarify existing standards and practices with regard to businesses and human rights, and then later to operationalize this with recommendations. His mandate was extended so that he could sort of come up with the actual guiding principles. What came out of this was first, in the first part of the identifying and clarifying component, was the protect, respect, and remedy framework, which I'll briefly discuss in the next slide. And second, the UN guiding principles on business and human rights, which were unanimously endorsed by the Human Rights Council in 2011, which scholars have noted is a rare event. The guiding principles, it's important to know that they do not introduce new standards, but they are an attempt to harmonize all the existing standards into one body of principles. The principles then contain 31 standards, and importantly, they also have practical guidance for how the principles can be implemented by businesses. At least that's the goal. The principle of human rights due diligence also has a prominent place in these guidelines, and the guiding principles have brought significant attention to the importance of human rights due diligence. Though it wasn't the first to bring this up, it has really brought a lot of attention to this concept. So next we'll talk about the protect, respect, and remedy framework. So Ruggie's framework consists of these three main pillars. The first, protect, is related to the duty of the state to protect against human rights abuses caused by third parties, including businesses. The responsibility then for businesses is to respect human rights, which entails the need for businesses to use due diligence to avoid causing or contributing to human rights abuses, including by their business partners, so throughout their supply chain. And third, greater access by victims to effective remedy, which can be judicial or non-judicial. So the emphasis here is on access to remedy. I want to briefly go into the concept of human rights due diligence, even though the guiding principles were not the first to use this term. Their importance, the importance in the guiding principles and the normative authority of the guiding principles has really popularized the concept and has contributed significantly to the widespread expectation that businesses should implement human rights due diligence processes. This area is actually one of the more exciting areas in the governance of business and human rights at the moment, as some states have implemented or are considering implementing legislation on mandatory human rights due diligence for firms headquartered in their territories. And I'm hoping that we'll have a little time at the end and I can return to these new measures very briefly. But human rights due diligence is a process that companies implement to identify, prevent, and mitigate and account for how they address potential and actual adverse impacts on human rights. The process should cover both adverse impacts arising from the activities conducted by the firm itself and those that are directly linked to its operations, products, or services by its business relationships. And this comes from the guiding principles itself. It therefore involves looking into the company's supply chain to look ahead for potential risks and to take steps to mitigate those risks. It therefore puts a degree of responsibility on a firm for human rights abuses that they do not directly commit, but are rather committed by another firm in their supply chain. However, the UNGPs soften this obligation somewhat by noting that it may be too difficult to apply human rights due diligence throughout a firm's entire value chain, noting how complicated and how extensive these supply chains can be, but suggest that firms identify the areas with the greatest potential risks. The UN guiding principles have already had quite some impact, as I've alluded to, particularly with regard to drawing attention to the impacts of businesses on human rights. The impact of the guidelines can be seen in the fact that they are referenced as standards in other international instruments, and already in quite a few since 2011. For example, the EU Commission has issued specific sector guides for the employment and recruitment, ICT, and oil and gas sectors, and how companies in these sectors can implement the guiding principles. Furthermore, the guiding principles have been incorporated into the most recent versions of the OECD guidelines, as I mentioned, and also the ILO Tripartite Declaration on Multinational Enterprises, the two we just discussed. And they've also been included in the United Nations Conference on Trade and Development, they've established an investment policy framework for sustainable development that encourages adherence to the guiding principles. And the European Investment Bank even incorporates the guiding principles into their investment policy, requiring certain commitments to the guiding principles for the companies in which they invest. So now we'll look at the implementation, because this has been the interesting part of all of these mechanisms so far. So a working group was established to promote dissemination and implementation of the guiding principles, and it can support capacity building and provide advice upon request from companies or from governments, etc. The working group carries out 1 to 2 country visits per year to assess progress and challenges in implementing the guiding principles, to meet with a variety of stakeholders, including worker associations and businesses, and to raise awareness about the UN guiding principles, and to establish both good and bad, to assess, both good and bad practices by businesses with respect to human rights. So they've been slowly, 1 to 2 per year, visiting various countries and making these reports. After each country visit, the working group compiles a report with recommendations for the country, and it's submitted to the Human Rights Council. And then the working group also holds an annual forum on business and human rights, plus several regional forums each year to share the results of these reports and to share best practices. The working group also supports states in creating national action plans for implementing the guidelines, which they encourage all states to do. National action plans are meant to build on the guiding principles and apply them to a unique national context. 23 states have created these so far since 2011, and 15 of the states that have created a national action plan are from the EU. Of course, there are still challenges and criticisms, despite the buzz about this mechanism. The first challenge relates to the fact that despite the guiding principles' emphasis on access to remedy, the mechanism does not include access to remedy. They do not have a specific judicial or non-judicial mechanism to address grievances. They do reference, however, the OECD national contact points as a potential mechanism by which individuals could seek redress for human rights abuses caused by businesses. So they do a bit of cross-reference there, but they don't themselves have a mechanism in place for addressing grievances. A second criticism is related, and it's that the working group mandate does not go far enough. Some scholars and commentators believe that it should be strengthened to allow it to engage in meaningful monitoring and review. And some argue that the language of the principles is too vague and allows for too wide of an interpretation. And fourth, although this should come as no surprise since it's a voluntary mechanism, that the guiding principles do not create illegal multinational enterprises is seen as a shortcoming by those who are pushing for more binding international rules for corporations. And this criticism, obviously, though, applies to all 3 of the mechanisms we've discussed today. And finally, some believe that the guiding principles are too soft with regard to states' duty to regulate human rights impacts of national businesses operating beyond national borders. I wanted to quickly put these 3 side by side so we can sort of see how they look next to each other. So you can see that in terms of issue areas, the OECD guidelines cover the most. It's most broad. Whether that's a good thing or a bad thing, that's not a judgment I will make at this point. Also, the target changes somewhat by the guidelines. So the OECD and the UN guiding principles are really focused on business and governments. The ILO declaration includes trade unions in its targets. With regard to enforcement mechanisms, we have the national contact points, which is certainly the most robust of the 3. And then we also have for the ILO, the company union dialogue and interpretation procedure, although, as we mentioned, this is harder to access for actual victims. And then for the guiding principles, we have the working group, which again is not exactly an enforcement mechanism, but because they do produce these reports on the country's implementation of the guiding principles, they're still nevertheless an enforcement mechanism. And in terms of access to remedy, we can see very clearly that there is in the OECD guidelines a potential for it. As we mentioned, some of the NCPs do not really see their role in this way and are more of a mediation platform, but at least some of the national contact points do provide access to remedy for victims. And in any case, victims can at least submit complaints. Whether or not it goes much further than that remains to be seen. But the other 2 do not include this function. I thought I would end by looking ahead at some of the more interesting areas that are coming out of mandatory human rights due diligence. So in 2017, France put into effect their duty of vigilance law, which requires companies that are over a certain size to take due diligence processes into account in their supply chains and therefore confers a degree of responsibility on them for human rights problems that occur in their supply chains. The Netherlands have adopted something relatively similar, although more narrow in focus, looking at child labor. And there are other, some other EU states are in progress of coming up with some national legislation on this. And at the EU level, there's been some interesting work done here as well. There's been a lot of research lately into potentially an EU level mandatory due diligence legislation. And they set up a shadow EU action plan on responsible business conduct, which was launched just last year. And several EU governments have already committed support, including the Belgian, German, and Finnish governments. And there's also been a conflict minerals regulation that was adopted in 2017 and goes fully into effect in 2021. And in the sector of mineral extraction, that's in particular for certain types of so-called conflict minerals, companies are required to implement due diligence processes. And then there's been some progress in other states with regard to their own national level mandatory due diligence. The German and Finnish governments have committed to introducing human rights due diligence legislation, and a parliamentary motion has been put forth in Denmark and a draft bill submitted in the Austrian parliament. And EU-wide, there's been a big focus of civil society. There's been big groups of parliamentarians and NGOs coming together to push for human rights due diligence, mandatory human rights due diligence legislation. So this is a really interesting area in business and human rights. And if you're interested in this, this is an interesting thing to pursue, I think. So I'm looking at this myself. But that's all I have for today. So if you have questions, I will be happy to answer those now.
Well,
Sorry, I also wanted to just point out that I mentioned that Charlene's lecture is next week, but actually it's Friday at 11. So make sure that you are back on this webinar platform on Friday at 11 a.m.
well, thank you very much, Kari. For the moment, we don't have any new questions.
Okay.
So I propose we end the lecture here. If there are any questions, maybe 1 second. I just get a question in. So the question is, do we observe a shift away from global centralized organizing non-voluntary governmental rules to a more localized decentralized way? And if so, is this a negative or a positive evolution?
Oh, that's a really interesting question. I think that there has been some recognition that it's very difficult to achieve binding international legislation for transnational businesses after the failure of the UN, when they started this in the 1970s, and after the failure to actually create binding legislation at an international level. And there's many groups that were against it, as you can imagine, a lot of hard lobbying. And eventually in 1990, that effort was abandoned. And I think it's at an international level, organizations are a bit hesitant to pick up binding legislation. The consensus has really shifted away from international binding legislation. However, I think it's becoming very clear that something has to be done and there has to be some sort of binding legislation on corporations. And so it's a bit easier to bring into fruition nationally without having to get buy-in from all of the other countries involved. So I think that's why we're seeing the new French law, which was really quite groundbreaking in 2017. There's a very interesting paper on how this came about that came out by Alice Evans. She looks at how this was a sort of a moment in history where activists came together with the right government situation, so it's sort of serendipitous, and it resulted in this legislation actually passing. Because as you can imagine, businesses are very much against binding legislation in this area. because it puts a lot of responsibility on them that they would not otherwise have for actions that they might not even themselves commit, but it puts onus on them to scour their supply chain for potential problems and to not work with certain suppliers if they're deemed to be a risk. So obviously businesses have by and large been against this. And one of the sort of, not excuses, one of the reasons that they use at the national level to oppose it is saying, well, yeah, we would like to implement this higher legislation and have these higher standards, but Germany hasn't done it. And so if we are required to, then for us to compete with the German companies, we're not going to be able to, so we're going to have to move borders. And so they sort of threaten, within the EU, they sort of threaten to pick up and move to another country that doesn't already have these national guidelines in place, or these national legislations in place. So that's why the EU level would be very important in this regard, because then you wouldn't have this threat of flight by these companies, and it would also level the playing field. I think companies are very concerned that they are remaining competitive with the other companies in the EU, especially since it's an open market. But yes, I think in general, it's easier to pull this off at national level, at least the binding legislation at the moment. And I think people are a little shy about going after binding international legislation after the failure of the UN to do this from the 70s to the 90s.
Okay, thank you. Maybe if I can add 2 more observations on this. One is, I think you should not always see the one happening in, let's say, in contrast to the others. I don't think we can separate what's happening now on the national level from what happened before on the international level. So actually the French law, the Dutch law, you also have a law in the UK, follow very much from the observation that these international non-voluntary, international voluntary rules are important, but that are very difficult to implement. So in that way, a lot of these national initiatives complement what's happening internationally. And in that way, it's not a trend towards more localized, decentralized way of functioning, but it complements what's happening on the international level. Now,
yeah, definitely.
Glad that on the international level, there is a bit of a tendency to every couple of years to come up with new initiatives. We had the UN Global Compact, which was voluntary in nature and did not work, but then we came up with strengthening the OECD guidelines, we came up with the UNGPs, and so on. And they are all, let's say, steps in a process, but sometimes we do reinvent the water or the warm water because the previous initiatives did not work. And in that sense, I do think that the shift towards quite strong locally binding legislation is quite important. Okay.
If you have other questions on these,
question, if I may.
Oh yeah.
The other question, is there a fear of confusion by setting up similar and parallel agreements like this? Particularly how the UN principles have been incorporated in the 2 other instruments we have talked about. Is there any sort of competition or jurisdiction issue between these instruments?
I wouldn't, because the ILO and the guiding principles cover sort of different areas and they cross-reference each other, there isn't really competing, you don't have different standards that would contradict one another within these instruments. They all are either referencing each other or they're supplementary. So I don't really see any that give like different opinions as to how a company should act. They all sort of agree more or less with one another. And in terms of jurisdiction, if a company is abiding fully by the OECD guidelines and the guiding principles, then there's no conflict. They can abide by all 3 instruments fully without there being any sort of conflict in their actions. So I don't really see there being competition per se. And in fact, the UN guiding principles are very explicit in that the OECD national contact points can be used as access to remedy for the guiding principles themselves. And so I think that they're all quite complementary in a way.
Yes, I agree with that. I just wanted to add that one should also note that the membership, let's say, of the systems are a bit different because the OECD guidelines are limited to the OECD members and a small group of countries which voluntarily sign up to the guidelines, but there's actually a small group of countries, while the UN guiding principles in principle hold to most countries in the world, and then expand a bit the scope of the OECD guidelines. So I think that's more or less all we have time for today. I would indeed invite you all for next Friday's lecture by Charlene, which also will take place at 11 through the similar platform we have used today. Thank you very much and have a nice
Thank you.
afternoon.
Thank you.